Hello, I'm Linda Brown Price, State Specialist for Family Financial Resource Management. It is my pleasure to introduce Lisa Marshall, an estate planning attorney, who will discuss the topic of key concepts and steps in agricultural estate planning.
Hello, my name is Lisa Marshall. I am an estate planning attorney. I'm an attorney licensed in Kentucky, and I predominantly do estate planning and probate and things of that nature. My office is located in northern Kentucky, but I've helped people around the state, and I've been asked to talk about passing down the farm, agricultural estate planning, and the nuances that come with that, because that's a little different than a lot of people who just have their house in the suburbs and cars, and that's about it with assets. When you have land that generates an income, there needs to be a little more planning that is done. And so I would like to just give you a nice overview as far as what those steps are and what you need to look at. Everyone's situation is very, very different. And so this by no means is meant to be specific legal advice for anyone, but just kind of giving the basics of what you should start thinking about and looking at as you're thinking about what you're going to do with your farm and your land, your agricultural assets, as you start looking towards retirement and beyond. So we're going to talk about a couple things, starting the farm transition planning process, just kind of what that looks like, determining who to include in your farm succession plan, asset-based considerations during your succession plan for your farm, how to involve your heirs, which can obviously be your children, but could also be other family members or anyone else that you have determined that you want to leave things to. Using life insurance for farm succession planning, and how that works overall with potential tax issues and things like that. So, most importantly, your goals need to factor in when you're looking at slowing down. If you are working on your land, you need to factor in what your land is providing you in terms of income for your retirement. And, before you start sharing and passing things to your heirs, whether that's during a lifetime or looking at doing it after you pass away, you certainly want to make sure that you are retaining what you need in terms of income, so that you are set up properly for your retirement. So in determining what to include in your farm succession plan, you need to think of a couple things. One is obvious if you just have one or multiple heirs. And if you have just one heir, you can probably stop listening now, because your situation is so much easier than those who have multiple heirs, that they're needing to determine how to pass this through successfully and allow it to still be generating an income for those who want to continue working there. And how, if you might increase the number of heirs in the future, that could be grandkids. If you have a grandchild that is actively working on the farm or in the agriculture, if you want to include them, what that looks like for everyone across the board. So those are things that you need to think about, because that's going to obviously direct what way you're going to go. So when there's multiple heirs involved, the farm transition process becomes a little more complicated. The more heirs you have, the greater the complexity, obviously. But you need to effectively navigate these waters. And that means that you need to have frequent, clear communication with those of your heirs, particularly those who are either capable of working it or maybe already working in the family farm. You have a couple different options to look at when you're passing things to your heirs, and that is whether or not they're already working in the farm, or if they have no interest whatsoever. As a parent, you want to provide pretty equally to your kids when you're gone, and so that may require some creativity when you're looking at keeping the farm intact, if that's what everyone wants. But having those clear and concise communications with your family and understanding what they want is super important. I've had many clients that I've sat down with, and The parents are assuming that everyone wants to continue working on the farm, even those that are heavily invested in it, but they never actually had that conversation with their kids. And lo and behold, some interesting information came out that, they were doing it because that was there to do and they could do it, but ultimately that was not what they had their life vision as. And that's really important to make sure that no one's making assumptions as to what's going to happen and who's going to be taking care of the farm after you pass away. So what you can do is, say you have 3 kids, maybe 2 of them are actively, or maybe just 1 is actively working on the farm. You could leave the farm, you could leave interest, like stakes of the farm. So you could leave that evenly. And if only one of them is interested in actually keeping the land together and working on it, then what you could do is set up something to where they have a specified length of time that they pay the other 2 their interest, so that they get the cash value for it. So that's one way that you can do it. Utilizing life insurance is another great way to compensate those who aren't getting the actual tangible asset of the farm and the income that comes with that. You're able to do that. Obviously, working with a team of professionals who understand the finance and the legal side of that is important, but there's a lot to do it. A lot of different options that you can do. One option is to just divide the farmland equally between your heirs and let them do with what they want to with the property. And generally, that is what a lot of people who don't have a succession plan or have not thought this through, that is their default. And what I mean by that is a lot of people who have land, who have kids, have assets, have known that they need to get a will. Some may even know that they need to get a trust, but they at least know that they need to get a will. A will, of course, is a document that describes to the probate court exactly what your wishes are, who you want to inherit, different items that you have, different assets that you have, and makes that very crystal clear. If somebody doesn't have a will, every state has what is called a law of intestacy. If you die intestate, that means that you do not have a will. So there is a law that is listed. Each state's a little different, that says, if you didn't have a will and you pass away, all of your stuff will go to, and it'll, whatever the first line is what it goes to. So, it could be spouse and kids, whatever your situation is. There is a law that will do that if you don't have a will. The problem with that is that generally that's pretty cut and dry, and that's usually not what people want to actually happen to their things. So it's very important that you create a will so that your wishes are known on everything, so that you're determining who is handling things when you pass away. So if someone just does a will and they have a farm, they could, I'll again use my 3 kids example. They could have 3 kids and they just divide all of their assets equally. Well, that's great. That's super fair in theory. The problem is that what they've done is that they've left a parcel of land that has 1 deed, usually. And what that does is lets the probate court and the executor know that, well, now all 3 of these people will go on the next deed. So where it might have been mom and dad own it jointly, and then maybe one passes away, leaving just the other person owning it. When that person passes away, you have the kids that will then step up and be included in the deed. So they will own it all together equally. However, since the kids aren't married to one another, that means that they don't own it as mom and dad did, as the husband and wife did, in what's called tenancy in its entirety, which means that they don't have any interest that grows if one person passes away. There's no joint rights of survival with that. And so what they have is what is called tenancy in common. So if I were to go out and purchase a house with a friend of mine, we're in no way related. And if we didn't specify how we wanted that deed, then we would own it 50-50. Also seems fair, except that if I had a falling out with my friend, She could decide that she doesn't want to own anything with me anymore, and she could sell her 1/2 interest. So I could end up owning half of a house with someone I don't even know, because that is how tenancy and tenants in common works. So what that means in terms of the farm is that if no planning is done, and I know that most people do not want this to happen, so that's why it's important to do planning. But if no planning is done, in my fictional scenario with the 3 kids, if those 3 kids now own the farm in equal parts, tenants in common, it means maybe the one child that wanted nothing to do with it wants to cash out. So now they are able to do that and have someone else own their third with these other 2 surviving children. So it's not a good idea to do it that way. There's a lot of other ways that are much more successful, but obviously that's going to affect the intent that the parents had, the original landowners have, or maybe not even original. This farm could have been in the family for many generations. So you also want to think of any sort of asset-based considerations when you're doing estate planning, machinery, livestock, anything like that, and how that goes. And make sure that that is notated in any estate documents that you have done, so that it's not just the land, but you're also notating what else is on the land in terms of personal property, or, well, I mean, actually animals are personal property. So whether that is non-living personal property or living personal property, you want to make sure that all of that is notated in your estate documents, so that everyone knows what is included and how things are divvied up. Okay, so different ways to involve your heirs in the transition process. Obviously, I said that we need to communicate, and you do need to do that to make sure that everyone's on the same page. And you want to make sure that it's you have some time to be able to start transitioning duties, and potentially start transitioning assets to the next generation, if that's how you're going to do it. Every year there is a set amount that you are allowed to gift to children, or to anyone, really. That does not have any taxable effect. There's no gift tax involved. So, around $16,000 a year, and you just have to check to what that is each year, because it does climb. You're able to gift that over to a child, to their spouse. There's a way to kind of get assets out of your estate if necessary. And that's a great way to do it. But that also means that you have to start thinking about it before you need to. Because obviously, the more that you pass down to the next generation, you're going to better equip them to handle things, but you're also going to make a smaller footprint in terms of the taxable impact that it's going to have on your kids when they do inherit. So that is something that you want to consider. So transitioning gradually is definitely the best scenario, but I am fully aware that most people are doing the day-to-day, and they don't think about this until it's a little closer to time. And that is why it's important to work with professionals that may be able to see some different techniques or transition methods that are going to be good. So just to kind of back up a little bit, because I'm talking about estate planning and talking about the farm itself, but I do want to go over just overall estate planning, because yes, this is specific to farms, but you need to have a basic understanding of estate planning and how this process works, whether or not you have a farm or not. It just so happens that you live on a much larger piece of land than I do. So as I indicated before, if you do not have a will, you are intestate. Everybody goes through the probate process in one form or another. So that would be what you have would happen if you did not have a will. But the documents that people need to have are a will, a power of attorney that is used when you're living still but unable to make decisions for yourself. That is very, very important when you own a farm, a working farm, because if something were to happen to you, whether you were just incapacitated, which is just a surgery or something in the hospital for a few days, you need to make sure that someone has the legal ability to answer questions, keep things going. God forbid there be something, major happen while you are kind of out of the loop, but you need someone to be able to legally handle things in your absence. Certainly, that takes an even more important aspect when we're talking about perhaps dementia or those debilitative diseases where it's very gradual. And you want to make sure you have those documents in place while everything is still working well and you know exactly what's going on. Because that just makes it easier for whomever is stepping in and handling things to be able to do that throughout the transition and be able to do that very smoothly, and that there aren't any breaks in that transition process. So so a will, a power of attorney for finances and things like that, and then you need your healthcare power of attorney or a living will, which addresses any type of things that kind of end of life decisions that you're able to make again while everything is fine. You're able to make those decisions versus putting that on the shoulders of your loved ones to try to think of what you would want to have happen when you are obviously not able to speak for yourself. So that is a very important document to have. And then a trust. A trust helps some assets avoid the probate process. I don't want to say that it avoids the probate process altogether, because of course there's going to be something maybe that you have, whether it's just your personal belongings that are not owned by a trust, and that would still be subject to probate, albeit a very short one and a concise one. But utilizing a trust, whether it is a revocable trust or an irrevocable trust, and there's benefits to both, will allow you to be able to handle a lot of what we talked about earlier in terms of issues with the deed and who owns what and who has a right to sell and things like that. By utilizing a trust and deeding the farm into the trust is a great option for a lot of people to be able to control how that's going to pass to the next generation, because you can put all sorts of caveats in there and explain exactly what you want to happen. And obviously you can't do that if you're just putting names on a deed or putting things in a will. It's just going to transfer to them. But if you utilize a trust that lets people, the next generation, be able to do different things within the what you're leaving behind, whether that is actually working on the farm or getting their inheritance per se in a different way. And so you can be very creative in that way by utilizing a trust. If you have own any property whatsoever, I always recommend that it be in a trust, because in the state of Kentucky, there's a very low threshold for the amount of assets that you can own and have what is kind of referred to as a very short, you dispense with administration, meaning your estate is so small that the probate court doesn't really need to handle all of it, and it lets it go right back to the executor, which is wonderful, because you've picked out who you want to handle everything. Let them handle it in a fast and efficient way. So if you own property, it's going to automatically put you up above that. And what that means would be what's called a full administration of probate. And that's your much longer, much more expensive, and of course, public process in terms of getting all of your assets through probate. And I highly recommend trying to avoid that if all possible. It's an expense that if you're going to plan anyway, you definitely want to plan around. So having a will, having a trust, having a power of attorney, and having a living will are 4 documents that, regardless of how old you are or how many assets you have, are really necessary for anyone. Farms are different though, and utilizing a trust is a great option, but there are other options as well. I know several families who have utilized different forms of businesses, whether that be an LLC or a family limited partnership. Same type of concept. It's an entity that will own the farm, and then those who are working in it will have shares of ownership, and it's just a nice way to be able to transition the farm to the next generation and still have it intact. And that is what most people are wanting to do. So those are different, just a very broad overview of different ideas that come into play when you're looking at transitioning a farm and estate planning. The same normal things apply with estate planning as far as what you need to have, what documents you need to have. But the biggest value, the biggest asset that you're going to have of value is going to be that farm because it generates income, and it's a large asset. So you want to make sure that you're doing proper planning in advance as soon as possible, not waiting until the last moment, to be able to transition that the way that you want. I will briefly mention estate taxes. This year, it's generally not a problem for most people. Federal estate taxes, the exemption level is set very high, so most of us are outside of that realm and don't really have to worry about it. However, having said that, that is something that can change at any time. And what I mean by that is we had a period back in many years ago at the kind of a 2000 time frame where any assets over $1 million were taxed. Um, every dollar over that was taxed at a rate of 40%. So that money, that federal estate tax money, is due 9 months after death. And that can end up being a huge amount because, unlike what the probate court determines are probatable assets or non-probatable assets, the IRS is able to look at all of it and say, all of that's your estate. So they look at a much broader range than the probate court does, and people's estates add up pretty darn quickly. So being that right now we're good, the exemption level is high, it could come back down at any point. And that's another reason why you want to make sure that you're looking at this in advance, because in years past, families that had successful small or mid-sized businesses or successful farms that generated income really had a hard time in passing that to the next generation or who they're wanting it to go to, because of the estate tax that's due. It kind of crippled that next generation, and there are multiple ways to help plan around that, so that is not as big of an impact. But again, it does mean that you need to look at it sooner than later. And again, everyone's situation is very different. I don't want to paint a picture that one specific thing is going to work wonderfully for everyone, but there are a lot of options. And if there's anything you can take away from what I've said in the last few minutes, is that start having those conversations with those that are involved in your family, your heirs who might be either farming next, and those who have no interest in it, that you're still wanting to leave something to, because everyone needs to understand their place in how it's going to transition. And you need to have those conversations. Once you've had those conversations, you need to get with people who can help you on the a financial professional, as well as a legal professional, who can work together and come up with a plan that is not set in stone. Things change, but a plan that is very workable, that you can start working towards and start that slow transition so that it's a flawless transition. And that is ultimately what you want. And if I could say, get in there and talk to somebody last week, that would be the time to do it. But as soon as possible. The fact that you're listening to this means that you already know that it needs to start happening. And so I hope that you're able to do that soon. Thank you very much. I hope you got something out of this.